Right to repair covers a wide and growing body of rights and obligations that entitle a consumer to repair their products. Broadly, there are two key phases that we'll be discussing today. Phase one has a long history. It's a fault-based entitlement, where a consumer can obtain a repair where the product does not conform with the terms set out in consumer rights legislation. However, it's only applied in limited circumstances, which we'll discuss later in the webinar.
The major difference is that the new regulation moves these requirements out of delegated legislation for specific products into the framework legislation that applies right across the board. That effectively creates a blueprint for rolling out these sort of groundwork provisions for right to repair to a much wider, larger number of sectors. And that really opens the door for a much broader right to repair. In terms of the status of this initiative, draft legislation was published in March this year, and that will now work its way through the EU's ordinary legislative process. So we estimate legislation may pass early next year, with rules starting to apply around 2025. We have had indications from the UK government that it's considering certain measures, and those include sort of mandatory disclosure around expected product lifetimes and requiring extended warranties to promote design for durability. At the same time, this is an issue that the UK Consumer Markets Authority, the CMA, has been exploring. They've been looking at how far the consumer law framework should go to address product obsolescence. And they've suggested that changes could be made under the consumer law framework to ban premature product obsolescence, which is what the EU is looking at, and also roll out a broader right to repair under the UK's eco-design regulations.